I still remember standing in line at security back in the early days, watching a family get pulled aside because they had flown into one state, but their driver's licenses were issued by another, and the officer on duty wasn't convinced they had a right to be there. It was confusing, it was humiliating for them, and frankly, it was a legal gray area that made absolutely no sense. We've all heard the horror stories, haven't we? The ones where someone tries to board a domestic flight or cross a state line for something as simple as a family funeral, only to be told by some authority figure that they need permission, that they need to justify their movement, that their right to simply be somewhere is contingent on government approval. It felt un-American because, in a very real sense, it was. But that era of uncertainty, that patchwork of confusion, just hit a brick wall. The Supreme Court just dropped a decision, and it's one of those rare moments where the legal world and the real world collide with a thud you can feel from coast to coast. Have you ever been stopped, questioned, or turned away while trying to travel domestically, and wondered if the person blocking your path actually had the authority to do it? Drop that experience in the comments, because what I'm about to explain is going to reframe everything you thought you knew about that interaction. The court just spoke with a voice so unified, so clear, that it's going to echo through every airport terminal, every highway checkpoint, and every state house from Maine to Hawaii. And trust me, the reasoning behind it is something you need to hear before you book your next ticket. Let me set the stage for you, because context is everything here. For years, we've lived under this unspoken assumption that if you're a citizen or a permanent resident, moving around inside your own country is about as fundamental as it gets. But if you've been paying attention, you know that assumption has been quietly tested time and time again. We saw it during the pandemic, when states closed their borders to their own neighbors. We saw it in the arguments over immigration policy, where the line between international borders and domestic movement started to blur in the public consciousness. We saw it in courtrooms where state entities claimed immunity from being sued in other states, creating a weird loophole where accountability vanished the second you crossed a dotted line on a map. It felt like we were slowly sleepwalking into a system where your rights depended on which side of a river you were standing on. Then came the case that changed everything. And I want to be crystal clear about what happened here, because the media headlines are going to be all over the place, and most of them will miss the point entirely. This wasn't one of those 5-4 splits, where the court is clearly divided along ideological lines, where you can predict the vote based on which president appointed which justice. This was a 9-0 ruling. 9 justices, ranging from the most conservative originalists to the most liberal textualists, looked at the same set of facts, the same legal arguments, and they came to one unified conclusion. When that happens, it's not a political statement, it's a constitutional earthquake. The core of the ruling, the part that applies to every single person living in or visiting the United States, hinges on something called mobility rights. Now, I know that sounds like legal jargon you'd fall asleep to, but stick with me. What the court essentially did was take a sledgehammer to the idea that your right to move is conditional. They looked at the fundamental structure of the Union, the very idea of what it means to have a country without internal barriers, and they reaffirmed something that should have been obvious. The right to travel freely throughout the United States is not a privilege granted by any state or local government. It is a fundamental right inherent in the very fabric of American citizenship and permanent residency. Think about the implications of that for a second. The court explicitly stated that any law, any regulation, any policy that imposes more than a trivial restriction on your ability to move across state lines, or that makes your movement contingent on getting government approval, is a constitutional violation right out of the gate. They didn't just say it was a bad idea. They said it infringes on the rights protected under the Constitution. And here's where it gets really interesting, and where the bilingual aspect of a different but philosophically similar Canadian ruling actually gives us a window into how these justices think. In that parallel case up north, the court had to interpret mobility rights in both English and French, and they chose the interpretation that gave the citizen the broadest possible protection. Our Supreme Court did the same thing here, but with our own constitutional framework. They chose the path that maximizes your freedom, not the government's control. So, what does this actually change on the ground? Let's walk through a few scenarios that are going to look very different starting now. Imagine you're flying from Los Angeles to New York. You check in, you go through TSA, you do the whole dance. But now, imagine a world where a state decides it wants to impose a health screening at the airport for incoming passengers. And if you don't pass it, you're denied entry into that state's territory. Under this new ruling, that's dead on arrival. The court was very clear that requiring government approval to enter a state or to travel within it is presumptively unconstitutional. That doesn't mean they can't do temperature checks in a pandemic, but it means they can't ban you from entering based solely on where you came from without a level of justification that is almost impossible to meet. But let's go deeper, because the real nuance here is about how this applies to different groups of people. The ruling drew a very careful line between citizens and permanent residents on one hand, and other categories on the other. This is where we have to pay attention. The court grounded the right of mobility in both the general rights of citizens and the specific rights of permanent residents to live and work. That means if you have a green card, you are standing on the same solid ground as a citizen when it comes to moving between states. But for non-residents, for visitors on visas, the rules are different. The court has historically given the federal government immense power over the border, and this ruling didn't erase that. In fact, in a separate but related thread of cases, we saw the court grappling with the travel ban, allowing the administration to block entry to certain foreign nationals from specific countries. That might seem contradictory, but it's actually a consistent legal principle. The power to control who enters the country at the border is vastly different from the power to control the movement of people who are already inside it. The court in the 9-0 ruling reinforced this by explaining that the right to travel is not just about physical movement. It's about dignity. It's about the autonomy of the individual. They used language that talked about how restricting travel forces a choice on people. Obey the restriction or face separation from family, loss of livelihood, or isolation from support networks. That's not just an inconvenience. It's a burden on the very essence of personal liberty. And this is where I want to challenge a common belief I hear all the time. People often think, well, if there's a crisis, the government can do whatever it needs to do. And the court directly addressed that. They said that while the government does get more deference in a crisis doesn't erase the Constitution. The government has to prove that the travel restriction is carefully tailored, that it actually addresses the crisis, and that there aren't less restrictive ways to achieve the same goal. They called it the Oakes test in the Canadian context, but the principle is universal. Even in an emergency, the government can't just trample on your rights without a damn good reason. Now let's pivot to a completely different travel scenario that this ruling touches in a surprising way: public transportation and liability. Have you ever been on a New Jersey Transit train or bus that goes into New York or Pennsylvania? Of course you have. Millions do it every day. Well, there was a huge legal fight over whether NJ Transit, as a state entity, could be sued in New York or Pennsylvania courts if something went wrong, like an accident. The lower courts were all over the place. New York said you could sue them there. Pennsylvania said you couldn't. It was chaos. And this goes to the heart of the 9-0 ruling, because if a state agency can operate in another state and then claim immunity from that state's laws, it creates a massive loophole in the idea of a unified national travel space. The Supreme Court, in a separate but philosophically aligned set of cases, stepped in to resolve this. They had to decide if NJ Transit was truly an arm of the state of New Jersey or just a corporation that happened to be run by the state. This might sound like inside baseball, but think about your rights. If a NJ Transit bus hits you in Manhattan, you want to be able to go to a New York court. You don't want to have to travel to New Jersey, hire a New Jersey lawyer, and navigate a foreign system just to get justice. The arguments in these cases were fascinating. NJ Transit argued that sovereign immunity is about dignity, about protecting the state from being hauled into another state's court against its will. But the victims argued the opposite, that New York and Pennsylvania have a dignity interest too, the right to protect their own citizens within their own borders. The court's eventual decision, which is still unfolding as we speak, will determine whether you have a remedy where you were hurt or whether you have to chase the government across state lines. It's the practical, gritty reality of what freedom of movement actually means when things go wrong. And let's not forget the economic side of travel, which this ruling implicitly protects. There was another case that flew under the radar involving tariffs on buses. A transit authority in Pennsylvania approved an extra $64,000 in payments for new buses because of tariffs on imported aluminum and components, and the very next day, the Supreme Court struck those tariffs down. Now, that was a trade case, not a travel case, but look at the connection. The cost of travel, the infrastructure of travel, is directly tied to these legal decisions. If tariffs make buses more expensive, transit authorities buy fewer buses, routes get cut, and your ability to move freely is constrained by economics, if not by law. The court, by striking down overreaching tariffs, was essentially saying that the free flow of commerce, which is the lifeblood of travel, can't be arbitrarily choked off by the executive branch without clear congressional authority. This brings me to a point that I really want you to sit with. The court in the 9-0 ruling emphasized that the right to travel is purposive. That's a legal term that means we have to look at why the right exists in the first place. Why did the founders and the framers of the 14th Amendment care so much about free movement? It wasn't so people could take vacations. It was so people could escape tyranny. It was so they could move to find work, so they could reunite with family, so they could participate in the national economy. It was about creating a single country, not a collection of small fiefdoms with drawbridges. When a state tries to restrict travel, they aren't just inconveniencing you. They are attacking the structural integrity of the Union. The court recognized that and put a stop to it in no uncertain terms. Now, I have to warn you about something. There are people in power who are not going to like this ruling. There are state officials who will try to find loopholes. They will try to frame travel restrictions as public safety measures, as health ordinances, as something other than what they are. And that's where you come in. You have to be the watchdog. You have to pay attention when a new rule is proposed that requires you to register to enter a county, or that limits travel based on your city of residence. You have to ask the question, is this a trivial restriction? Does it require government approval? Because if the answer is yes, this Supreme Court just gave you the ammunition to fight back. Let me give you a real-world hypothetical based on the reasoning in the case. Imagine a scenario where a state, worried about a resource shortage, decides to limit the number of out-of-state vehicles that can enter a particular national park. They set up a checkpoint and say, "Sorry, you're from Ohio. You can't come in today. We're saving it for locals." Under the old way of thinking, maybe they could argue it's a resource management issue. Under this new ruling, that's a direct infringement on your right to travel. You don't need their permission to visit a federally protected area. You are a citizen of the United States, and that land belongs to you as much as it belongs to the person who lives down the road. The depth of this ruling goes even further when you consider how the court handled the idea of precaution. Some governments argued that they should be able to restrict travel just in case something bad might happen, even without proof. It's the better safe than sorry approach to constitutional rights. The court rejected that outright. They said that while precaution is fine for environmental policy, it's not a freestanding justification for locking people down. The government has to show an actual problem, not a theoretical one. This is huge. It means that future travel restrictions can't be based on fear and speculation. They have to be based on evidence. And look at how this interacts with the world of maritime travel. Something we don't always think about when we discuss domestic movement. There's a pending Supreme Court case about cruise ships and liability for actions in foreign ports, specifically Havana docks. It seems unrelated, but it's actually the same principle playing out in a different arena. How far do U.S. laws protecting property and person extend when we travel? The court in the Havana docks case is wrestling with whether a U.S. company can be sued for using confiscated property in Cuba. If the court limits that liability, it might encourage cruise lines to be less careful in foreign ports, which affects passenger safety. If they expand it, it might make travel more secure. The 9-0 ruling on mobility sets the philosophical tone for all of these cases. The default position is freedom, not restriction, protection, not immunity. I want to share a personal insight here based on years of watching how these things play out. The average traveler has no idea how fragile their rights are until they are tested. I've seen people get into arguments with gate agents, with police officers, with TSA, thinking they have rights they simply don't have. And I've seen the opposite. People who had rights but didn't know it, so they just accepted being turned away. This ruling is a game changer because it arms you with knowledge. The next time someone in authority tries to stop you from moving freely within this country, you need to know in your gut that they are the ones who need to justify their actions, not you. You don't need a permission slip to go to your sister's funeral. You don't need a waiver to drive through a state you don't live in. That's the heart of it. But here's the catch, and this is the part that keeps me up at night. A right that you don't exercise is a right that atrophies. If we all just quietly accept the next temporary checkpoint, the next emergency travel permit system, because we're too tired or too scared to push back, then this ruling becomes just words on paper. The court can declare your freedom, but only you can live it. That's why I asked you at the beginning to share your stories. When you share that time you were questioned, that time you were delayed, that time you were denied, you are building a record. You are reminding everyone that these aren't abstract legal concepts. These are real moments of friction in real people's lives. And let's talk about the economic consequences for a minute, because travel isn't just about freedom, it's about money. The travel and tourism industry in this country is a multi-trillion-dollar beast. It employs millions of people. Every time a state erects a barrier to travel, they aren't just annoying a few tourists. They are punching holes in the economy of their neighboring states. The court understands this. They talked about national unity and a common identity, but underneath that is the cold, hard reality of commerce. If goods can't move freely because people can't move freely, the whole system seizes up. This ruling protects the arteries of American commerce as much as it protects your personal liberty. I think we also need to look at how this ruling protects the most vulnerable among us. Immigrants, even those with permanent resident status, are often the most hesitant to assert their rights. They worry that any confrontation, even a justified one, could jeopardize their status. This ruling sends a clear message to them. Your right to move is not a second-class right. It's protected at the highest level. If you are a lawful permanent resident, you have the same mobility rights as a citizen, period. That means you can travel for work, for family, for education, without fear that some local ordinance will put you in a legal gray area. Now, I want to challenge a narrative that's going to pop up in the next few weeks. You're going to hear pundits say, this ruling is radical, that it ties the hands of local governments, that it's an overreach by the court. Don't believe it. This ruling is actually deeply conservative in the best sense of the word. It conserves the original understanding of the Union. It goes back to the fundamental principle that we are one nation, indivisible. The radical ideas were the ones that tried to splinter us into 50 different countries with border controls. The court just restored the baseline. Let's go back to that family I mentioned at the beginning, the one getting questioned at security. Under the legal landscape before this ruling, the officer had a lot of room to be suspicious, to ask for more documentation, to delay them. There was no clear, ringing declaration that their movement was a right, not a privilege. Now there is. Now, if that officer persists without a legitimate, specific reason to suspect a crime, and traveling from another state is not a crime, that officer is opening up their department to a massive constitutional lawsuit. That changes the dynamic. It shifts the power back to the individual. I also want to touch on something that doesn't get talked about enough: the psychological weight of travel restrictions. When you know you can't leave, or you can't enter, it creates a sense of being trapped. It breeds resentment between regions. It turns your neighbor into a potential threat. The court, in its ruling, implicitly recognized this psychological toll. By affirming the right to travel, they are affirming the importance of contact, of mixing, of the friction and beauty of a diverse population moving and interacting. A country where people can't move is a country that is slowly dying. And what about the practical advice for you right now? If you are planning a trip, don't change a thing. But if you encounter a new state or local rule that seems to restrict your movement, do your research. Look at the source. Is it a health order that applies to everyone regardless of residency? That's probably fine. Is it an order that specifically targets people coming from another state? That's a red flag. That's the kind of rule that this 9-0 decision was designed to strike down. And if you find yourself in that situation, don't be aggressive, but be informed. You can respectfully ask the officer, "Can you show me the authority that allows you to stop me based on my state of residence?" You might be surprised at how often that question alone causes them to back down. This ruling is going to ripple through the lower courts for years. Every time a state tries to get creative with a travel restriction, someone is going to cite this case. It's going to be the shield for travelers and the sword for lawyers challenging overreach. The fact that it was 9-0 means there is no ambiguity. There is no, "we'll wait for a different court." The message is final. I remember reading about a woman in Canada during the pandemic who was denied entry to a province to attend her mother's funeral. She had to wait 10 days for an exemption. 10 days of grief compounded by bureaucracy. The court in that case eventually said her right to mobility had to give way to the common good. But our Supreme Court just looked at that logic and said, not so fast. In a free society, the common good is served by protecting rights, not by suspending them at the first sign of trouble. That woman's story and the thousands like it are the reason this ruling matters. So, as you go about your day, as you plan your summer road trip or your flight to see family for the holidays, take a moment to appreciate the legal architecture that makes it possible. It's not just roads and airports, it's the Constitution. It's a unanimous Supreme Court ruling. It's the idea that in this country, you are free to go. And that freedom is not a gift from the government. It's a restraint on the government. They work for us. They don't get to tell us where we can and cannot be. I'm curious to hear your thoughts on this. Do you feel more secure in your travels knowing this ruling is in place? Or do you think there are circumstances where states should have more power to close their borders? Have you ever been in a situation where you felt your right to move was unfairly restricted? I really want to know, so take a second and drop your experiences, your questions, your concerns in the comment section below. Let's get a conversation going. Because at the end of the day, the law only works when we understand it, when we talk about it, and when we hold our governments accountable to it. This ruling is a victory for that principle, a victory for the idea that we are all Americans first and residents of a particular state second. And that is something worth protecting.